slides I want to mention to you to complete our discussion on this module. Now, there are various numbers that we need to remember in our module, which by now you should be able to understand. We have Cap 73. We have 19, meaning Rule 19 for priority with will. We have 21, meaning Rule 21 for interstate priority of grant. In actual practice, we also have 60A, which we have mentioned in the beginning of this lecture in terms of public notice. There are two other things in terms of numbers. One is 33. This is section 33 of Cap 10 that deals with removal of personal representative that we just briefly mentioned before the break. And then another hot issue is this one. This is 56. 56 is section 56, Cap 10, on estate mean. It's asked for estate account. In recent years, there are a growing number of court applications resulting in quite a bit of judgments under section 56 asking for accounts, showing that the personal representatives are required to give accounts on estate administration. So therefore, this is called estate account. But the law is not very strict on this. They don't expect us like auditors. But there are certain things that we need to do. First of all, the law under section 56, it says that, well, if required by law, you need to produce an account so under an affidavit, meaning you do it by affidavit to say, I attach the account and I say this is true. So verify the account. So this is section 56. And also in the oath, there is a clause that states there that you give an undertaking to the court. You say, I will exhibit a true and perfect inventory and a just and true account. So in our practice, it is inventory and account. They mean probably the same thing. Inventory is the property of the deceased as at the date of his death. Take inventory, take stock, okay? These days can be now reviewed in Form N4.1, the schedule of assets. Then where a grant has been issued, in the first page of the grant, also said, having recited that the grant to the grantor, the grantee, the personal representative, recorded that the personal representative, either executor or administrator, has agreed with the court to exhibit a true and perfect inventory and of all singular estate and effects and render a just and true account. Whenever required by law so to do. So they said whenever required by law to do. So the law in fact goes like this in simple terms. First, we have inventory, meaning the assets of the deceased as at the date of his death. And then there is an account. Account starts from the date of collection. Assets received received by the personal representative, and then payments out of these assets and other income. So there is a going account from day one when you receive the assets, normally after the grant is issued. So this is account. So inventory and account, inventory, you talk about the death of the deceased. Account, you look at it from the point of view of the person representative. So much that he has received, you have to record them. So much has been paid, you record them. So you record them as and when it occurred. But you are under an additional duty if required by law, meaning required by court, as may be applied by any parties concerned, normally the beneficiaries or the creditors, then you should be able to produce this estate account and verify under the affidavit. To say, now this is the update position. By this oath, I say what is stated here is a true account as at a particular date. So, without an order, without a request, already a duty to keep inventory and account. With an order, then you should be able to prepare this account and supply to the court and supply to the party to show what the update position is. So that is what the requirement is. This is the form we find on Tristan and Coot, the English authority. So you see that paragraph 1, there is a true inventory. So this is similar to N4.1, the schedule that we list in Hong Kong. And you end up by paragraph 3 to say that, apart from what is listed there, nothing else that has come to my hand. So this particular precedent is how you use an affirmation to verify the account. So that is the precedent. And the account, as you can see in paragraph 2 here, marked A. That is the estate account. So this is an affirmation this is an example for an affirmation to verify an account which is called A, Exhibit A. As a formality, no such thing provided. The law says, in future, if we need to do something on account, we need 4 things. The authority comes from this judgment, Zhou Chak Q of Hong Kong. You need 4 things. Number 1 is the opening balance. You started with the opening balance. Usually by N4.1, you've got the inventory. With the opening balance, you say what assets have come to your hand. This is the opening balance. I collected the balance of the bank account of Hong Kong Bank. I received $5,000. That is the opening balance. There are several bank accounts, one from HSBC, one from Hang Seng, one from BOC. So these are the opening balance. And then you put in all the rest just like a journal. So this is what it says, number 3 there. The movement. You have deposited $1,000 day 1, day 2, $2,000, day 3, $3,000. So there are $6,000. And then somebody has been paid to a law society or court fee. And then the money transfer from one account to another account, from your personal representative or administrative bank account with, let's say, BOC, and then you move from BOC to Hang Seng Bank. This we talk about the personal representative bank account. And the whereabouts, this is important. Okay, there are 6,000 collected, you use up 1,000, the balance is 5,000. Where are they now? Oh, I collected cash which I'm now holding in my pocket. The present whereabouts, the balance is 5,000, which is now held by me as the administrator in cash. Movement, well, day 1, deposit in bank A, day 2, deposit in bank 2, day 3, payment to creditor C, day 4, now all these are to be shown. And support the account with documentary evidence. We don't need to be an auditor. As we follow this with a simple spreadsheet, chronologically, in, out, will give you a balance. Everything with the supporting voucher and supporting receipt. That will do. Then immediately, there is the closing balance. So today, I submit an asset account. As of today, there are only $3,000 now held by me in my hand. And then the receipt of payment. If we got all this, this will be the asset account that we need. So you don't practically need an auditor for this purpose, for simple estate. Okay? And what you see in this slide is a very complicated stuff. This is an extract from this judgment in the case of HCMP 1927 of 1995. It's complicated, very complicated. And then at the end here, you see there is the total receipt of estate. Item 26. You see here. Then this is total receipt. And then there is the balance. So all you need to do, I think probably is with an Excel spreadsheet that will do. And then this is the second part, the breakdown of expenditure items. So you see, this is the total expenses. Total expenses is there. So then you have the balance. I show these two slides to you in order to illustrate that there is in fact no one fixed format. You need the opening balance, you need the movement, you need the closing balance. And this case is a famous case done by the judge who has retired now, is Judge Wu. Judge Wu has since been promoted to the Court of Appeal, and he has now retired. He was a judge supervising all these public rights and all this voting stuff in Hong Kong. He was a criminal judge, very tough. And in this case, he did a civil case. This is a civil case. The judge found him very mad. He was very mad, as seen from the judgment. It is a case of a daughter. The daughter used to be an actor in ATV. I think she is a Miss Asia, very bright and talented. So, she later went to England to study LLB, and then he asked his father to pay for the education expenses. Then his mother died, leaving some estate to the father and to the children. And she was so unhappy about the way the father became the administrator of the mother, allowing the younger brother to take advantage of, very low rent to use some of the shop premises, and then not giving a fair estate account. So she sued her father in a capacity as the administrator. And then there was argument. How come we have paid you school fees in the past few years? You study law in England, okay? So these are income payment. So the plaintiff argued that, well, this payment of educational expenses are part of the duty of the parent. This is not income distribution. This is what you need to pay me, father, for my study. It was argued. And eventually, the judge Wu find it probably he was so unhappy about the way the daughter has treated the father, not having produced a good account of the mother who has died. So eventually this account was not prepared by the father. This account was prepared by the judge. He gave the judgment. He spent a few days doing this account. And in order to say that, well, what is the estate account? How should be distributed? And then the daughter, not happy with the judgment, appealed to the Court of Appeal. Court of Appeal dismissed the appeal by the daughter, saying that you asked for an account, estate account. Don't you see that the judge has already produced an estate account? There's no need for any further account, even though it was produced by the judge. So dismiss the appeal. So you can just see how things are to be worked out. It's complicated because there were so many estates, landed property for rent, etc. But anyway, things will just work out in the way that we have discussed. Opening balance, movement, whereabout, supporting vouchers, and closing balance. That's it. Okay? So these are things that you need to understand on this. Now we talk about this judgment. Assignment. Now, let me tell you this. There is no absolute answer for the assignment. The assignment will give you some marks. It is by virtue of the judgment that I want you to get more exposure to this module. But to begin with, I expect you to pick up a way more consistent yourself as a legal practitioner. In order to do this, you need to have a respect in me and a respect in yourself. As reflected in some past assignments, I'll let you know what I consider is disrespect. You are expected to give an assignment of 2,000 words. As you can see, I have seen a lot of assignments prepared by students because they are so busy. Some of them refuse to give the assignment, and some who does, or some who do, will give you a pile of I don't know what. I have seen some give me out of the expected 2,000, some give me 500 words, some 400 words, some 3,000 words. All this are not to be expected in grant application. you need to comply with what you are expected to do. So, it should be no more than 2,000, but close to 2,000. Because this is what you are expected to submit. Number two, some of you are so busy, and some said, Mr. Wong, I don't have a computer, so I can only write. I don't even have a typewriter. So you use your ball pen and sometimes mix up with your pencil, and some give me blue ball pen, black ball pen, red ball pen, like drawing a painting. All this reflects very poorly on you because this is not an art class. You are expected to reflect something more professional, as if you are giving something in the profession. You are in the professional field. What I would expect, I want to see something more decent. First, let's start with the font, like making a living. There are top margin, bottom margin, from right, from left. Papers are very inexpensive these days. You don't need to give me an assignment by using only one page and squeeze in all the answer writing back and forth on the front page and then at the back there, and give me 1 or 2 pages, and that is your assignment. This does not reflect good on you because I'm sure that you will not be able to read your own masterpiece later on or for the rest of your life. So, I want something with a reasonable margin on both sides, and on top and the bottom. And then, if possible, use a computer. All right? I don't want to see your handwriting because you're not in a master yet. Use a computer or use a typewriter. Computer is better because you can correct. Typewriter will waste your time. And then, as far as fonts is concerned, I would prefer no smaller than 12. You can use it from 12, 13, or 14. And I want, well, I don't demand it, okay? I would recommend that with the sentence, the line spacing should be 1.5 or 2. I say this because this is what you will be giving by way of counsel advice in future. This is what you would be, at least to your client. Print only on one side with proper paragraph, and in each paragraph there is a paragraph space in addition. So, in your masterpiece, would probably something like this. Do not print on both sides. If you don't have papers, ask Mr. Wong, I'll give you free of charge. In case you are not able to find a computer, telephone me, come to my office. I'll provide a free service to you. Okay? So I expect you guys to be able to act like a counsel, not even a solicitor. Another thing is, you are not writing a poem. Do not use one paragraph by using only one sentence. I have seen some brilliant students, almost one page, only 2 sentences. This is no good because you are expected that this shall appear either as advice or as a submission. short sentence, simple English, more full stop. Okay? So at least even you don't know what you're asked about, at least you present something which is presentable. Okay? Then, your student number, your name. Don't just give me your signature. You'll be surprised. Student will send in the assignment giving a signature which I cannot recognize, and I make mistakes because I cannot read your signature. I don't even know who that is. All these are basic training to reflect that you are in a position to present a legal document in a decent way to show that you have paid all your school fees in such a good school, Hong Kong U Space. All right? If it's not presentable to me, the chances are your work will not be presentable when you go and work. Don't look at yourself as a clerk. You are not. I want you to expect yourself to be a future solicitor, to say the least. Okay? So that is my expectation. That probably will apply to all assignments in your future work. Now, in terms of what the contents of this judgment, if you have the assignment question with you, there are 3 questions. Do not write more than 2,000 because this is what Hong Kong U Space requires. So it would be close to 2,000 but under 2,000. 3 questions. Now, to make sure that we are on the same page, we are talking about the judgment which, as you can see on the top right hand side, it's HCA 635/2019, and you see the neutral citation at the 4th line down on top, which is 2021 HKCFI 1787. Now I have made some typo in the initial assignment, so make sure that this is a judgment that you're talking about. And this is the case of Uniform Loretta as a plaintiff. And the first defendant is Charm Investments Limited. Got it? All right. So you got the right judgment. There are several judgments in this case reported. So don't get on the wrong judgment. Otherwise, you will be answering the question by referring to the wrong material. Now, this case is a very interesting case for various reasons. And it's not difficult. It's not difficult. But factually, it can be fairly complicated. In the legal practice, we have something called, for litigation, we'll have the issue, we have the submission, we have the persona dramatis, and we also have something called the chronology. These are the few elemental stuff that will be required in order to convince the court or the judge that you have crystallized the core issues in question. Question number 1, state the chronology of the deceased relating to the purported marriages, the wills, the death, and the grant of the deceased. Now, in the judgments, there are discussions under various places by the judge on matters concerning various parties, including but not limited to the deceased. Okay? Or I particularly narrow it down to the chronology. Chronology is the events in a particular dates, following the dates. Okay? So this is the chronology. So day 1, I make a will. Day 2, I get married. Day 3, I die. Day 4, a grant is issued. So on and so forth. This is what we call chronology. You are only required to record or to state the chronology that relates to the deceased, not about the plaintiff or the defendants as such. So if you have exceeded the number of words in question, then you can remove the other parties which are not related to what you are asked to answer. Because I just want you to focus on things concerning the deceased. Another thing is, the deceased, there are all kinds of factual events. I only asked you to discuss on these several parts, namely the purported marriages. Purported are sometimes used because they're being challenged, like purported marriages, purported wills, so on and so forth, meaning somebody is challenging the validity of it. But let's say if there is alleged to be a marriage, we don't care about whether this is valid or invalid. So something concerning marriage, something concerning will, something concerning death, something concerning grant. These are the only 4 sets of facts that I would like you to select. So, by this process of elimination, please exclude the parts that does not concern the deceased. I don't care about what happens to the wife or to the other relatives. They may be significant in the judgment, but not significant in the question. And then you just focus on marriage, on will. Death is very easy, when he died. Grant is easy, initially, when he was granted. Now, for those who have read the judgments, you will know that this is a case concerning some disputes. They are trying to dispute something, including the marriage, including the will, and including the grant. The only thing not being challenged is the death. Okay? Is that the kind of questions that set here are basically on the earlier parts of the judgment. As you look at paragraph 2, then you know. Now, okay, start with paragraph 1. Paragraph 1 sets initially on 2 things. Number 1, you will see that there are various court actions. Paragraph 1, first line, already there are 3 actions. In fact, there are more if you read further down. And then, in this particular judgment, the court is to consider not 3 court actions, but to consider 2 sets of applications under this case 1115 of 2019. So there are 2 sets of applications, and if you look at paragraph 2, the judge goes on to say what that 2 sets of summons are all about. Remember, in our practice, summons, S-U-M-M-O-N-S, refers to one summons with an S. There are 2 summonses, okay? S-U-M-M-O-N-S-E-S. Why the judge used 1 set of summonses? Then maybe probably there are more than 1 summons which are being connected together. The thing I want you to remember is that when we talk about 1 summons, still already there is an S. If there are more than 1 summons, then we say summonses, as it says paragraph, the first line. So there is the summons taken out by the defendants. They ask for a stay of further proceedings pending the court determination of a probate action. So this is the first confusion that may occur to you, because in the paragraph 1, the first paragraph, there are already 3 court actions, all of 2019. And then in paragraph 2 there is the 4th action, which is the probate action, 28th of 2019. Probate action is Order 76, is for the determination of the validity of a probate, or of a grant, probably fighting for a grant, and also including the revocation of a grant already issued. So when you read through, you know what the problems are. Then there is a second set of summonses, which is made by the plaintiff, Loretta. Loretta applied for an order, asked the court to appoint Loretta himself as the administratrix. Administratrix means administrator, but just a female administrator. Here she asked for an appointment in her favor as the administrator pendente lite, or pending light. So this is a Latin terms. What it means is when there are disputes on grant, the court not yet fixed, not yet determined whether the application is valid or not, whether the grant is to be issued in favor of whom, the dispute not yet settled, not yet final order made. But before that, there is a need for estate administration. So during this vacuum area from date of death to the date of grant, during this waiting period, we need, because of the urgent reason for estate admin, Loretta said and applied to the court, because of the urgency of the matter, I now apply to the court to appoint me as a provisional or a temporary administrator, pending the final disposal of the probate action. So at the end of the day, the court may say, Okay. Loretta, I think what you want this court to determine is in your favor. Here, there is a will. The court will say the last will is valid. As the last will is valid, and as you are the sole executor named therein, so probate is granted to you in respect of the last will. There is no more dispute. But before that day comes, Loretta now say to the court, my lord, that final decision may take place in 2 years' time, after you have time to hear the submission from the parties and the evidence. During this interim period, because of the need to proper administration on this transient period on provisional basis, I want this court to order that I can apply as the temporary administrator. So this is what she is applying. In order to carry on each of the 3 actions. So in other words, in first and second paragraph, you know that there are already 4 actions. There are already 4 actions. And Loretta, the wife, is now applying please apply me as the provisional administrator, so that I can sue or defend the 3 actions, which is concerning the validity of shareholding transfer before the deceased died, or the transfer of the shares, or the transfer of other money. So you can see the gist of it. The deceased in his lifetime, in fact, he was very close to his brother and close to the children of his brother, the nephews. And then the deceased somehow has a close relationship with Loretta, the plaintiff, so close that there were several marriages. And as far as the deceased is concerned, he is known to have made more than 1 will in his lifetime. And so, if you turn to page 28, paragraph 53 and paragraph 54, it says, in the circumstances, I think the APL application should be adjourned sine die with liberty to restore. This is the second application referred to in paragraph 2. APL means administration pending light. That is to say, the appointment of provisional administrator, pending the final determination of the will in question. The judge ruled at paragraph 53 to say that Loretta's application for appointment of a provisional administrator is adjourned, so that she is given the permission in future when the time comes and when the need arises, so that she can apply to the court for the determination of this APL application to be resumed. Okay? And then at paragraph 54, for the above reasons, the stay applications are dismissed and APL application are adjourned sine die with liberty to restore. 54 deals with both of the two summonses. The stay application is the first summons. The first summons is stated in paragraph 2. Stay of further proceedings pending the determination of a probate action, which means the defendants ask the court to say, well, the 3 court actions referred to under paragraph 1 not to continue. Do not continue yet. This is what we call stay. Stay until when? Stay until the court has the chance to decide the probate action on the validity of the will. The argument is clear. Loretta in the 3 actions are applying to the court to challenge the transfer of the share in Chang. She doubted it. One of the reasons is that no consideration, unsound mind. So the 3 actions under paragraph 1 are similar. Attacking the invalidity of the inter vivos act by the deceased in transferring the assets of the deceased in favor of the several nephews, including Charm, which hold a landed property, very expensive, variable. So, the first application, the defendants are the nephews, as well as the company in question. They say that there is no need to determine all this if, at the end of the day, the court should rule that the purported last will is not a valid last will. Then everything goes back to the previous will. Then things will be less controversial because of the testamentary disposition differences, as reflected in paragraph 54. The court said, no. Stay application dismissed. Meaning, the 3 actions in paragraph 1 will continue, so that there will be no delay, no prejudice. Then, APL application adjourned sine die. The court also refused the application of Loretta, the plaintiff. There is no need to appoint a provisional administrator. So, in that, the 2 applications under paragraph 2 are different aspects of applications during this interim period, so that until the will is finally determined, things are being protected. For the defendants in the first summons, they say, don't sue us. For the second summons, Loretta, the wife, said, of course, I need to continue. I need to do it as quickly as possible. They are siphoning off the assets. Assets need to be protected. Someone needs to be in place. The court dismissed the first application and adjourned the second application. So all this discussion in this judgment boils down to how the court decides on this. Okay? Now, let's get back to the assignments. You please read the first portions of the judgment in order to give sequence. When did the deceased marry? Reportedly, he had married more than once. When did the deceased make the wills? Reportedly, he has made more than one will. They all appear in the initial several paragraphs. For the first will, is recorded in paragraph 4. It is a Chinese will. And then spend more time to read at paragraph 3 because it gives you the background, including the 1994 will in paragraph 4, so paragraph 2, as well as the second will, which is paragraph 3, so paragraph 5. Okay? So the first will is paragraph 4.2. The second will is paragraph 3.5. Got it? And then again, you read carefully on the background paragraph 3, you know the purported marriages. The purported marriages, you look at 3.2. You look at 3.2. This is on a divorce in 1972, remember? But this only concern Loretta. The assignment asks you to describe the purported marriage or marriages, not of Loretta, but of the deceased. That is to say, the man. We don't care about the former marriages of the plaintiff. It's none of our concern in this question. There are some interesting discussion on the two marriages, if you can observe. This goes back to our study on the validity of marriages in Hong Kong. If you recall, when we talk about the rule of intestacy at lecture 5, the significant date was 1971. And here, the kind of date-sensitive matter is paragraph 3.3. There is the customary marriage since about 1972. That's interesting. Since about 1972. And they live together as husband and wife. So that's what we call the common law wife if the marriage is not valid. Is it a valid marriage? Then you have to look at it carefully. And then there is another purported marriage, which is in paragraph 3.4. See that? 3.4. So there is a formally married by a civil celebrant So there's a 2010 marriage. And 3.5, there is a 2010 will. So all these will be relevant to our discussion for question 1. Then please find out when the grant was made, if at all, and see how it goes. But the focus is on the 2010 will and the 2010 marriage, which is preceded by a 1972 customary marriage. So these are the stuff that you need to discuss. If you can explain your observation, that will reflect your proper understanding on the background on this judgment. Then, question 2, I leave the rest for you to expand. Otherwise, all your answer will be identical. Question 2, with reference to Rule 19 of Captain A of priority for grant where deceased left a will, please discuss the priority of various related parties with reference to the Chinese will, dated 1994. Now, this question asks you to talk about Rule 19, which is testate priority, and the question asks you to do it by reference to the first will only. Do not give me an answer on Rule 19 by reference to the 2010 will. Okay? So look at the Chinese will in paragraph 4. Is it paragraph 4? Yeah. In paragraph 4.2, and compare it with Rule 19 to say or to determine where they stand. There are more than one party, and discuss how they stand within the framework of Rule 19. You have to go to Rule 19 to examine the various order of priority, at least from priority 1 all the way to priority 5 or 6, 19.1, and then all the way down to 19.5 or 19.6. That will give you the right perspective. If you start off with first executor, then we will have the RE as trustee, we have RE for life, then we will have the 4 options under the 4th priority: substantial assets, partial intestacy, and then the final residuary beneficiary. And then 19.5, you have the specific beneficiary, which is the non-residuary gift, and to see whether 19.6 is applicable. So these are the stuff that I expect you to be able to compare and to include them to where they should stand in your opinion. And I repeat, I asked you to focus on the first will. So don't give me a masterpiece by comparing Rule 19 with the 2010 will, because that shows that you are absent this evening. Number 3, Please comment on the rule of intestacy in Hong Kong in relation to the inheritance of the estate of the deceased. Assuming that the deceased died intestate with a sizable estate and that the parents of the deceased having both died before the deceased. There is no fixed answer on this question. I expect you to be able to look at the judgment, to discuss the various parties under different contexts, assuming deceased died without a will. Now the factual area here gives you the deceased died with 2 wills. The question asks you, not on this, but assuming both 2 wills are invalid, so that the deceased died without a will, how are you going to determine the various parties in the context not on Rule 21? Because Rule 21 is priority only on grant application on intestacy. The question 3 is a question on priority of inheritance. If that is the case, then ask yourself, what is the applicable statutory provision? That is to say, the rule of intestacy insofar as it concerns with inheritance, not application for grant under Rule 21. Okay? So that I'll leave you to discuss all this, and you only need to show me that you have studied all this, and then I welcome your analysis. Got it? Not more than 2,000. The best way for you to do, as I have recommended always, get a small group, your buddies, read the judgment first, have a discussion among yourself, and map up your strategy and how the answer is to be answered in your particular way. Now, there is only one way that you can definitely fail in the assignment, is to copy. I have actually seen students in the past. They must be in a hurry, so they create a masterpiece. But then when I do the marking of the various assignments, suddenly I see so much similarity in that, even with the grammatical mistakes. So, of the 2, one must be a copycat. Now, this is not what I want, because I want you to digest it and write it out yourself. Don't worry about grammatical mistakes, because I emphasize short sentence. I have already told you what I want in the 3 questions. The focus, if I ask you to discuss on intestate, you discuss on intestate. Do not in the question give me what the entitlement on testacy. Oh, under the first will, inheritance will be like this, blah, blah, blah. Under the second will, inheritance like this, blah, 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 if the second will is valid. That would be off the question. Okay? Because I asked you to discuss on intensity. Now, basically, this is what needs to be done. No difficult word. You don't need to copy difficult legal jargon. Just write things, explain very simple terms. That will do. I just want you to convince me that you have read the judgment. Write out your work, simple stuff, in good format to show that you have the capacity to be a future solicitor or counsel. That's all I need. Okay? I'll stay behind for another 10 minutes. Any student who have questions to ask may ask. Okay? Otherwise, thank you very much.